Hi, my name is Kevin Snyder of Snyder Law, and I'm an estate planning and elder law planning attorney. And I'd like to talk to you today about a question that I recently received when speaking with a new client, and I think it's important for all you to know. The question is, should I add my sister as a joint account holder on my bank account just in case I get sick so they can have more freedom of access to my bank accounts? Is that a good idea? And I thought, what a great question, because it touches upon a couple different things, like what does it mean to be a joint account holder of something, and what actually happens in situations if something happens to you or them. And so here's what I would say in that situation. Number one, if you are holding something jointly with another person, like a bank account, and you're jointly on title or of that account, you are what they call as joint owners. You're holding it in joint tenancy, so you're joint account holders. That means that account is as much of yours as it is theirs. So that can be very beneficial in a situation of crisis, because they'll be able to have access to that account because they're also an account holder. And after you pass away, that account is theirs in their name. There's no need for any court involvement in that situation. It immediately goes to them. That may be a good thing or a bad thing. But let's look at pragmatically how that can play out. So you have created an estate plan with a certain design of how things should go. You have named certain beneficiaries. Maybe your sister is one of them, or whoever the sibling is, but you have others. You have your own children, your own spouse. If you have an account, a joint account with somebody else, like the sister in this example, you pass away, that account goes directly to them. It does not follow with what other instructions you may have left in a will or a trust, for example. They don't have to, the new account holder, your sister, doesn't have to follow what your wishes are in this other planning, because they're a part owner. That could be problematic and against what your design is. In addition, what happens during life if something happens to them? They have some lawsuit, or they have to file bankruptcy, or they're going through a divorce. Guess what? That account that you are jointly holding with them is as much theirs as it is yours. So it's subjected to their life, including their liabilities in these situations. That account may get attached to a judgment of a lawsuit. It might be included in a divorce or a bankruptcy, even though technically that is your money. So if you're concerned about any of this, my advice to you would be to have a conversation with an estate planning attorney more about your other options of how you can incorporate some other good estate planning with using a will, a trust, durable powers of attorney, a compilation of all of them in order to get the best results, where you might not have to attach your sister as a joint account holder in order to get the result you want, which is for your sister to have access to your money to help care for you in times in which you're not able to authorize that vocally because you're unconscious or you've passed away. There are other ways that we can go about doing that to make the access as immediate and as impactful, but yet not being exposed to your sister's or other family members' liabilities. So hopefully that was helpful for you. Again, my name is Kevin Snyder of Snyder Law. If you have any other questions about this topic or others, please reach out and contact us. We're happy to talk with you, always happy to help. And please feel free to review some of the other videos we have on the website. Others have found them very helpful. So again, Kevin Snyder, Snyder Law, and look forward to talking to you soon. Have a great day.